for inviting me. And can I preface my 15 minutes by saying I'm not a financial expert, so please, no questions about blockchain. My eyes are just glazed over. Okay, I'm going to talk about arbitration and the benefits of it in the financial industry. Now, it's a very exciting time for development and innovation. And according to the UN, Africa's growth has consistently outperformed the global growth rate for the past 7 years. And this trend is to continue. And in order to sustain the growth and close the gap with the rest of the World Bank estimates that the continent will require $93 billion, $93 billion worth of commercial and social infrastructural development. Now, in the past, as we all know, we've had natural resources fueling playing a key role in generating income. But currently, there's less resource-based income than in previous years. And with a finite amount of funding available from traditional institutions, the need to actively seek alternative sources of finance has never been more pronounced. With the rapid expansion of the financial industry comes an increased number of disputes. And this is where arbitration comes in. The first slide, please. Thank you. Now, the first and second, and I think the last one are self-explanatory, so I won't go into them. Disputes arising from data breaches and privacy violations. It's right to say, of course, that this has become a hot topic in recent years. And with the digitalization of the financial landscape, biometric data, etc., privacy has become a hot topic for so many reasons. Not only are policymakers introducing new regulations, but also consumers are becoming more aware and sensitive about their privacy. Previously, nobody gave it a second thought, but now it's something that's quite important. I recently heard data described as the new gold. And with each instance of data mismanagement in the news, consumers are demanding more transparency. How is their data collected? How is it stored? What is it being used for? How is it shared? Why is it being shared? And more importantly, what happens when there's a breach? We have Cambridge Analytica. We can have the same thing here if we haven't had it already. But if that is to happen, it's only right that the consumers have a recourse. Why wasn't their data kept safely? Why was their data allowed to be shared without their consent? What can they do? Now, of course, they can litigate through the courts for years and years and years, or they can arbitrate. And the same applies for privacy violations. And I'll come on in the second section to deal with the advantages of arbitration. I hadn't quite finished. Thank you. Disputes arising from fraudulent transactions. Now, when there's a fraudulent transaction in a financial institution, I'm sure there would and there should be criminal proceedings, but I'm dealing with it from the point of view of the innocent victim who has lost money, lost their reputation, been a victim of fraud. Now, all they did is to entrust their funds to a bank, a lending institution, an investment company. Why wasn't that money kept safe? Why was somebody or were people allowed to take that money? Was there negligence involved? again, it's only right that they have recourse to a means of seeking redress. And disputes arising from regulatory breaches, and I know we've spoken a lot today about regulation. And it's right, as Shupo said, the purpose of regulation is to keep the consumer safe, to protect the consumer. So what happens when things are not properly regulated, and as a result, the consumer is left unsafe? Shareholders, for example, may see their shares go down through no fault of their own, but as a result of such a breach. Now, what are the advantages of arbitration? The next slide, please. Sorry, this is just some examples of some new trends. I think the first set are quite traditional ones. We now have Libra. I won't go into that. I think we heard a lot about cryptocurrency and the huge potential it has in regulating alternative currencies. Again, disputes arising from alternative funding systems and lending institutions. We're all moving away from our traditional banks. There are private companies who lend, there are organizations, young startups who lend money. What happens if money lent is used for something it wasn't supposed to be for, or if money is lost, or money isn't transferred? Again, arbitration comes into this. And again, disputes arising from data protection, which I think I mentioned previously. The next one, please. The advantages of utilizing arbitration to resolve financial disputes. All of these, I'm sure the arbitrators in the room will be very familiar with. Speed, efficacy, cost, flexibility, and convenience. Now, from a financial point of view, if one wants to seek recourse for money that's been lost or plundered or invested wrongly, and as a result somebody has become out of pocket, you want this dealt with as soon as possible. Why should people hang around for years to wait to recover their money? Flexibility and convenience, again, that's something that is key, especially when you have international institutions. Where should the arbitration take place? How soon should it take place? How long should it last for? The use of experts throughout the process. Now, this is quite pertinent to the discussions we had this morning. I recently attended an arbitration where it was to do with an international hotel chain. And one of the arbitrators had a certain expertise in Italian hotels. And it was invaluable having her input because she was able to tell us about the different nuances, what happened, who the various firms are. And when it comes to things like blockchains, I think it's very important if you have somebody in the room who understands the various implications, who can advise on how to move forward, give expert advice. It certainly smooths the process along, and it's very helpful. Again, privacy and confidentiality. Uh, it's often the case that, I think it's almost always the case that financial institutions do not want everybody to know that something awful has happened. One of their staff or some of their staff have acted inappropriately, money has gone missing, contracts have been breached, etc. As we all know, privacy and confidentiality is key. And again, arbitration helps in that regard. Also, preserving corporate integrity. I think this overlaps with the last one, and I should have said at the start, there is a degree of overlap between some of these. But of course, we're dealing with huge institutions who have reputations, many of which go back many, many years. And that integrity is preserved when disputes are resolved privately so that the press don't get hold of it, social media doesn't get hold of it. Again, also preserving trade secrets is very important for privacy and secrecy to remain intact when there's a dispute that's being settled. Lastly, I'm not sure how many minutes I have left. The arbitration clause. Thank you. The arbitration clause. For the arbitrators present, we all know there's been so much litigation about what constitutes an arbitration clause. The golden rule is make it crystal clear so that there is no doubt that there is an arbitration clause. Don't make it ambiguous. Don't use fancy, long English that gets lost in translation. I think I'm just under the 15 minutes. Thank you.